This is chapter 12, Resignation and Retirement. You will see this will be a quite short lecture and chapter. So our objectives here are to explain why an employer should formally accept an employee's resignation in writing, explain why a resignation must be voluntary and unequivocal, also explain an employee's obligation to provide a notice, and I know this may surprise many of you. And last but not least, explain the implications of the elimination of mandatory retirement at age 65. So, resignation, when the employees decide to leave the company, when they decide to resign. So resignations, to be valid, they must be truly voluntary. So there can't be any signs of a threat or of any acts that would cause the resignation to be not voluntary, but a response of what the employee was allegedly at least suffering in the company. And when resignations are truly voluntary, the best practice is that the employer should accept the employee resignation in writing. Again, for legal risk perspective, the more records in writing the employer has, the better off they will be in case there are any complaints with the Employment Standard Board or any lawsuits, any wrongful dismissal lawsuits. And when the resignation is valid, the employer will only owe the employee their outstanding wages and benefits, not more than this. So there's no required notice. We'll see the required notice will be on the side of the employee because it is the employee that is resigning, and there's no severance pay because the employee is actually resigning. It is important for us to distinguish between a quit, a valid resignation, and a dismissal. So quit and dismissal will be different. So a valid resignation or a quit is where the employee voluntarily intends to end the relationship, and this is also known as the subjective test. It is subjective because it is related to the intention. So courts, if needed, they would assess or try to assess the intention of the employee. So that's why it is subjective. And there's also the objective test that is related to the acts of the employee, and a reasonable person would believe that those acts or acting in that manner would mean resignation. So remember, I mentioned about a reasonable person before, and a reasonable person is not a perfect person, is not an average person, but it is a person as much similar as possible to the person who actually acted in that manner. So in this case, as most similar as the employee. So this is the objective test. Okay, so objective test, how the employee acted, the way the employee acted in the eyes of a reasonable person. And the subjective test is the intention. So what does the intention of the employee tell the employer. Was the intention a voluntary one or not? So a voluntary intention to end is required here. And also with regards to the objective test, resignation may also be inferred from the employee's conduct. But intent to resign must be clear. So, in other words, the employee may be acting in a way they mean to resign. So they are being careless, they are not being as skilled as they were before. So they are clearly, objectively speaking, they are clearly acting in a manner. They intend to resign, they intend to end the relationship, but the intention must be clear. So employers here would be better off, and the best practice would be to meet both the subjective and objective tests. Then there would be a valid resignation. Okay? And to reiterate, to reinforce, so the crucial elements are voluntary intention plus the actions that follow through on the expressed intention. Okay, so the employee actually handed in a letter, a resignation letter, or sent an email, or even sent a text, and that may be followed by questions on when their end date will be, how they can return the employer's equipment, and any other belongings they are keeping. Okay, so that is what is considered a valid resignation, a real quit. There will be circumstances, or we'll see now examples of situations that would not be deemed a quit, would not be considered a valid resignation. So first case is when the employer informs the employee that they will be fired, they will be dismissed unless they resign. So this is actually duress. This is actually, the employee is actually under coercion or under a threat. Hence, here the quit is not valid. It is invalid because there's no voluntary intention to end the agreement. The act of ending the agreement would only take place because of duress, because of the coercion, because of the threat of the employer. Another example is when an employee is absent from work for some days, for some weeks, even for some weeks, and then is told by the employer that they will be deemed a quit unless they return by a specific date. This is also a threat, and also, as we'll see, or as we've seen in chapter 11, the employee is entitled to a progressive disciplining. So the employer, in other words, is required to start a progressive disciplining process. So they would call, and they would say that they would give a verbal warning. Eventually, they would send a written warning, second, third, and then a last chance warning. Then, if a progressive discipline process is worked through, then there will be dismissal for just cause, but there will never be a quit as a response of the employee because of the employer's threat even though it's a slight threat here, it's a light threat. So if you don't get back to work, I'm going to fire you. But that cannot happen like this. As I said, it requires a progressive discipline process. Okay. And a third example is when an employee storms out and say, "I quit." So this is not considered a valid resignation unless the employee confirms that quit statement by remaining away from work or returning the equipment after a reasonable period of time that they could calm down. So at the first instance, when the employee storms out in a meeting where nerves were out there, so this cannot be regarded as a valid resignation. Employer should be cautious, should give the employee some time to calm down, and then in case after this time, after some period of time goes, like some days, and the employee confirms they actually want to quit, then this will be a valid one, may be a valid one. Just make sure as an employer you get this in writing. But if the employee gets back and says, "Sorry, I stormed out, it's not feeling okay, I didn't wake up well that day," or anything else that happened, "I didn't like what I heard," whatever it is, and they apologize, uh, they may get a warning, they may suffer the consequences of a progressive discipline process, such as, "Hey, you cannot do this in front of everyone, so this is your first warning," etc. But they cannot be fired for just cause, nor should the employer consider their quit when they stormed out as a valid quit, a valid resignation. Okay, so those are three important examples that are not considered a valid resignation or a quit. So once you have a valid resignation with you, so preferably in writing, employers should not fire the employee, because if they fire the employee after the employee has given the resignation notice, the resignation letter, they may be sued for wrongful dismissal. So if you dismiss someone after they resigned, it means you have to give them the required dismissal notice or pay in lieu of notice. So employers cannot do this, should not fire employees who have validly resigned. If you don't want the employee to be working because you believe they may treat clients in a bad manner, or they may underperform, or they may be a threat to the secrets of the company, etc. So what you may tell them is, "Okay, you don't need to come to work. We'll pay you normally for the remainder of your notice, resignation notice days, but you don't need to come to work anymore." Okay? So you can do this as an employer, but you cannot and should not fire the employee who has resigned. So wrongful resignation. This may surprise many of you, but under common law, so it means it is not prescribed in the Employment Standards Act, but the courts require that an employee has a legal obligation, or the courts have determined that the employee has a legal obligation to provide a reasonable notice of resignation. I know many of you or some of you have already heard that people just call one night before and say, hey, thanks for the job opportunity you gave me, but I'm resigning. I'm not coming to work anymore. So they just call and say bye. Well, this is, again, illegal under common law, and the employer could pursue any damages they suffer. In real life, however, this doesn't happen frequently, or this rarely happens, because the legal costs are not worth pursuing damages employees may cause to the employer. One thing here that is important, however, for higher paying jobs, the damages the employer may suffer based on the notice of resignation. Sometimes they are 30 days, 60 days, 2 months. So for higher paying jobs, employers may decide to pursue damages in court based on wrongful resignation. So again, they are very rare, but they are not impossible, because common law courts understand and have determined that the employee also has an obligation to provide a resignation notice. So duties here apply to both sides. Employer has to provide a dismissal notice to the employee according to the minimum requirements of the Employment Standards Act, and the courts also require the employee to provide reasonable notice of resignation. Okay, and if employers and employee agree on their employment agreement, a 30-day resignation notice or 60-day, so that period will apply. Again, if an employer would want to sue an employee who did not provide a reasonable notice of resignation, they would sue for the amount of salary, benefits, bonus, any other compensation the employee would have during that resignation notice period, which in my example is 30 days. Okay, so that's what the employer would pursue. And the idea of the resignation notice is, the purpose actually is to provide employers sufficient time to hire and train a replacement. So again, as I said, there's no statutory rule in BC. This requirement comes from common law courts, from case law. Some exceptions, they are important to mention. So if it is a custom, or if it is because of the employee health or safety, or because the contract was frustrated. Frustration here is when there's an outside event that causes the employment to be impossible. For example, the company went on fire and cannot operate anymore, or the employee became partially or permanently disabled, totally permanent, with a permanent and total disability. So the contract is frustrated. In law, frustration is when the contract cannot be performed anymore, but not because of the act of the parties, but due to outside events that were not in control of the parties. So those are exceptions in which a resignation notice would not be required. And again, damages may be recoverable in court. So employers may want to pursue their damages, even though this is very rare. mainly for low-paying jobs. So that's on resignation. So now we look at retirement. Retirement, pretty simple, straightforward. So when employees attain the age of 65 or 70, they may retire or they can retire. Back in 2011, so 10 years ago, government of Canada repealed sections of the Canadian Human Rights and also the Canada Labour Code that permitted employers to force employees to retire once they reached a certain age, regardless if they were still able to perform their job duties. So that was a great victory for human rights in Canada, because as we know, we learned from the beginning of the course, chapter 1, if I'm not mistaken, the Charter of Rights and Freedoms in its section 15.1 prescribes the equality rights, reading that every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination, and in particular without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. So, if no one can be discriminated under age, among other things, how could um, government government departments, government corporations force, or federal employers force employees to retire once they reached a certain age? So that was, again, a great victory for human rights in Canada. And nowadays, there isn't such forcing, or employers cannot force or demand employees to retire. Within the province, for provincially regulated employees and employers, there's no mandatory retirement, and the statutory definition of age is not modified to reflect an age 65 retirement. But Section 13.3b of the BC Human Rights allows for an exception. What is the exception? So when the employee reaches 65 and there's a bona fide retirement need, so there's a reasonable and fair justification for the employer to require the employee to retire because of the job duties. Remember, not on the person, but on the duties of the job. Then the employer may demand the employee to retire. Another exception is if the employee is enrolled in a pension plan. So in BC, for example, also in Alberta, most registered retired plans, they are acceptable under this exception of the Human Rights Code. So again, there's no mandatory retirement, so employees can work as long as they want. However, there are exceptions for bona fide retirement requirement based on the job duties, or the exception on the pension plan. So most pension registered retirement plans, BC and Alberta, they fit or they fall into this exception. So the fact that mandatory retirement was abolished, they pose some concerns for employers. So first one is that the employer now has the onus, has the burden of proof for a bona fide occupational requirement with regards to age. It is the employer that has to provide records and have records that over a certain age an employee cannot perform well on that job position. There's also a performance management issues. There may be the employer may need to be assessing performance of the employees on a more regular basis, or it is very important also to document properly the performance assessment, performance evaluations, in case the employer wants to make use of them for mandatory retirement or for demanding the employee to retire. The employer may be in a position to have to offer accommodation. So they may believe they have a bona fide occupational requirement based on age, but actually, if they accommodate a little bit, the employee can keep on performing their job duties as well as a younger employee. So the employee may be actually in a position to have to accommodate if this is the case. Just remember that accommodation is limited to the extent that it does not cause an undue hardship to the employer. But again, there are issues here. If it is determined that the employee has to retire and such determination is legally valid, the employer may have issues to consider the reasonable notice of termination. And the best way here is to consider the common law reasonable notice. And the common law reasonable notice, we'll see in more details, but it takes into consideration the length of service of the employee, their age, and age here would be 65, 70, availability of other jobs, etc. So the reasonable notice here could be months, could be years. So that's also an aspect of concern for employers. And also pension. Eventually, employers would have to offer pension benefit plans in a way to fall into the exception of NBC Section 13(3)(b) of the Human Rights Code. And that may mean more cost, more expenses to the employer. So those are the main issues that surround the abolishment, mandatory retirement. And that is something that employers need to take very seriously to avoid legal risks and further complaints, lawsuits from former employees. So that's what I wanted to share about resignation and retirement. I told you it would be quite short. Thank you. Bye.